Good morning. We're going to get started. My name is Dustin Robinson. I'm the founding partner of Mr. Cannabis Law, which is a full-service law firm focused on the marijuana and hemp space. I'll be presenting the speakers today, but rather than reading off their bios, I'll let them tell you all about themselves. But before that, I'll give you guys a quick story on a few of the panelists, because they actually, three of them were actually very largely responsible for me getting involved in the cannabis industry, even though they may not even know it. My first C-Lab event that I went to, Ari, who's our moderator today, he was one of the panelists, and so was Kobrin. Ari was litigating several of the Florida cases relating to cannabis, and he is still very involved in those cases. And Zach at the time was in-house legal counsel for Knox, which is now Fluent, and now Zach is actually working at Akerman with Ari. But at the time, they were somewhat in opposing positions relating to that litigation. And so at that panel, they were both able to provide their legal arguments with one another. And it was very, very interesting for a new attorney to come in and see these cutting edge legal issues and watch two super smart guys give very, very rational legal arguments about both positions. And after their panel, I actually ended up following them around a little bit while we had some drinks, and I just listened into what they were talking about. And it really represented some of the interesting issues that we have going on here in Florida. And those two guys were at the forefront. And then Vijay over here, who's another panelist, he's one of the first people I took out to lunch to try to rack his brain and understand what the cannabis industry is all about. Vijay is the in-house legal counsel or chief compliance manager, or whatever his title is. He'll tell you more about it, for GrowHealthy, one of the MMTCs as well. So Vijay was able to give me some great information. Vijay's been at the forefront of all this. He's been very involved from the very beginning. So is Zach and Ari, and then Adam Starkman over here as well. He's gonna give you a little background on himself also. But all these guys are very involved in the industry right now. They know a ton about the challenges that are going on when you're already licensed. I know a lot of people are interested in getting licensed, but I don't think they realize all the challenges that come even after you're licensed. So without further ado, I'll hand the mic over to the moderator, Ari.
Good morning, everyone. My name is Ari Gersten. I'm a partner at Akerman in Miami. I've been practicing cannabis law for about 5 years now. I've represented several MMTCs and prospective MMTCs in Florida and in other states. I'm also one of the counsel for Florigrown in the litigation challenging vertical integration in the state of Florida right now. Very happy to be on this panel, and hopefully we can answer some questions that you might have. And the peanut gallery over here is going to make some jokes about it. And then let me pass it on to my other panelists to introduce themselves, and then we'll move on.
Appreciate it, Ari. Like Dustin said, I wear many hats at GrowHealthy, but on paper, I am the compliance manager. So what that means is that from all facets of operational standpoint, from cultivation, dispensing, processing, transportation, inventory, marketing, they all touch a compliance aspect. So I oversee that component from our operational standpoint.
Thank you. So as Dustin said, well, first I would actually correct him. It was, one smart lawyer, Ari, and me arguing. My name is Zach Kobrin. I've been in this space now since 2014. I was previously General Counsel and Chief Compliance Officer for Consortium, which is the parent company to Fluent, formerly Knox Medical. Helped bring them from one state, one operational license, 35 employees to when I left. Operating in 4 states with licenses in Canada and Colombia, and publicly traded. Now, as Dustin said, Ari is a partner of mine, an attorney at Akerman, and I represent multiple MSOs, multi-state operators, as well as ancillary businesses, not just Florida, but from coast to coast pretty much. So California, Michigan, Illinois, you name it. Excited to be here, and hopefully talk about some interesting topics.
My name is Adam Starkman. I am the Director of Business Development for Green Growth Brands, where I oversee M&A. Green Growth Brands operates in Nevada, Massachusetts, and currently in Florida, where I also serve as Director of Operations. We work closely with Ari and Zach as our attorneys here in Florida, as well as Akerman in additional capacities. So yeah, I'm excited to be here today. Thank you for having me.
All right, everybody, let's start it off with a question here. And we're going to start with Vijay. What would you consider to be the most difficult aspect of your job?
Right. So these, I would say, time and scope. These plants don't stop growing, and just the time that's dedicated towards all facets of this operation, because it's not just one hat. You have to take into consideration a lot of different factors when you're dealing with the plant. Not only what the government is telling you from the Florida state perspective, but we're talking security protocols, EHS protocols, OSHA, PPE. It's more than just putting a seed in the ground and then watching it grow. From that perspective, having a total encompassing, wherewithal to understand what is involved with actually growing that plant, that's difficult. And also, just the travel, the time. Florida is different in any other state. Ianthus operates in 11 states, and GrowHealthy is their Florida subsidiary. So Florida is unique in the perspective that we can open up a lot more retail locations than, say, Massachusetts or New York. Right now it's at 35, with the exception of Certera and Trulieve, who can open a little bit more, and that cap expires in April 2020. So this just the sheer facet of all those retail locations, coupled with all that personnel. Going into this, I didn't realize how much human resources is a pivotal part of this, because you're dealing with hundreds and hundreds of hourly employees, and that in and of itself brings a lot of issues from the employment law perspective, from training to termination to whistleblowing. They're all items that need to be on the radar, and I would think that that's the kind of most difficult perspective from my point of view, is taking all that information and having a handle of it and delegating appropriately. Zach, you got it?
No, you covered that really good. The hardest part to being an MSO, or? Hardest part of the job. So I would say, kind of stepping, what Vijay said is 100% correct, that it's never as simple as you think it's going to be. In that you have to keep in mind, look, marijuana, cannabis, it's nothing more than a widget, right? It's just the most highly regulated widget you have ever dealt with. So you have to not only deal with the everyday issues that Vijay talked about of running a large business, 100, 200, 1,000, I think, Trulieve's got almost, over 1,500 employees. When you start becoming a multi-state operator, it's even crazier. So, but you have to deal with the individualized regulations state by state. Florida's regs are different than Pennsylvania, it's different from California, Massachusetts, Nevada. Whether or not you're dealing with an adult use state or a medical state. So there are different factors you have to deal with. For me, compliance was beyond the legal side, I can appreciate what Vijay does, having dealt with it. Compliance to me was one of the most, if not the most important aspect to these operators, right? If you are not maintaining your operational compliance within the bounds of your regulatory scheme, not just that, but business compliance and corporate compliance, making sure that your board of directors, if they want to issue new stock, they actually paper that decision, not just, even if it's the same three guys, making sure that you've got your corporate governance and compliance tracked out. So I think it's managing and understanding the balance of that, and also I would say it too many times, but I would always admonish people for saying, you know, when people would say, "Oh, I apologize for the stupid question," right? There is no stupid question, because if you think in this space, especially with multi-state operators at this level, that you think you know everything, then you are going to fail dramatically, right? You cannot be afraid to ask questions, no matter what it is, and don't be afraid of what the answers are going to be, because a lot of times the answers are going to be not what you expect or want, you know. And then the other thing I think also is, it's one thing to tell your client, your boss, your CEO, you can't do this, right? But what I always took the approach of, don't just say what you can't do, but actually take the analysis a step further to think about, well, if you want to do X, here are the ways you could possibly do it or achieve the goal. And you may not be able to get there by that direct straight line you're thinking about, but we may be able to work a few ways around it to get you close, right? Whether it's selling a different type of product, or, you know, figuring out ways to open up more stores, you know, whatever the options may be. I just, you know, my take on it was, don't always walk in saying, no, you can't do that, it's not that black and white. But actually think about the business aspect in the context of the legal and compliance aspect.
Well, Zach, let me follow up on that question for you. Would you say there's an area of the industry that's overregulated at this time? And would you say that there's an area of industry that's underregulated at this time?
Are we talking Florida or across the
Well,
board?
let's just limit it to Florida at this point.
An area of the industry, well, I think an area of the industry that may be overregulated, I don't know if this is necessarily overregulated, but it's rather, there are a lot of aspects that is not clear within the confines of what, say, an MMTC can and can't do. Am I getting to this part of the conversation? Yeah, for example, so like right now there's, and this could be perfectly timely, so there's an issue that's going around with the MMTCs right now as to whether or not they can sell hemp-derived CBD. Okay, that is completely, you know, DOH has one opinion, and, you know, many people have differing opinions on it. I'm not going to go too far down the rabbit hole of a legal analysis, because I can't. But that being said, that's a perfect example of, there should be more clarity between the Department of Agriculture, who is going to, within the next 2 months, start licensing, you know, the sale, the growth, production, and sale of hemp CBD, and whether or not an MMTC, as a creature of statute, you know, is allowed to sell the product with or without approval from DOH. And to that extent, what are those approval regulations? What do those guidelines look like? That's an example of not necessarily the industry lacking in something, but rather the evolution of the industry, right? Cannabis is marijuana and hemp. It's both of them together, right? So you see the industry has evolved in a certain way that you now need to make sure the regulators and the government agencies are actually keeping up, right? I think other areas where we potentially in the future, and I'm kind of foreshadowing, you know, where you may see under-regulation now, and I'm not saying I'm for or against the coming over-regulation, but if Florida ends up spinning to adult use, you're going to see a lot more issues on the local level. For those that deal with land use, NIMBY, not in my backyard, you used to see it 30 years ago with strip clubs or, you know, smoke shops or tobacco, you know, or liquor stores. I think the ongoing, I don't want to say battle, but the juxtaposition of local governments wanting local control compared to what the state has set up on the preemption issue. And for those that don't know, state law in Florida says that a local government is preempted from basically zoning out dispensaries. So you either treat them like you would a retail pharmacy or you prohibit them outright. I think that issue is probably something that may not seem underregulated, but if Florida goes adult use, it's going to be severely underregulated, and I'd be shocked if we didn't see some litigation on that aspect.
I think something that's very overregulated in Florida is probably delivery. to have a robust delivery mechanism to allow delivery throughout the whole state, yet require 2 drivers at all times for product, make it pretty cost prohibitive. There's enough measures in place to make sure the product is secure, but nobody's been able to really roll out an adequate delivery system for patients. I think given part of this 2 persons at all times. And I think touching on what Zach said, I think the looseness in the Florida regulations around the MMTCs create so many gray areas that led to tons of unnecessary litigation, delays in the program, delays in authorizations, delays in licensing. I think more robust framework probably will create a little bit more clarity.
And that's actually, what Adam just said is actually a perfect example of, most people don't like more regulation, but this is an industry where more regulation actually helps the industry because it provides that clarity you need. That may be something where, on the larger scheme, Florida is, I hate to say this, under-regulated to the extent that there is not enough clarity in all facets of the industry.
And keeping on the topic of regulations, to the panel, have you encountered any sort of regulation that you found incredibly surprising in your work? Something that you're like, wow, this is something that I don't know how anyone thought of this and why we have to deal with it throughout the course of your employment?
Yeah, I can take this one. So a perfect example, we were doing an inspection for an Orlando location, and the front glass windows were not frosted. But then going into the walk-in area, there was another window, and that was not frosted either. The rules stipulate that MTC can't do any advertising or marketing in the view of any public road, street, or sidewalk. The department inspectors, they came there, they said everything looks fine, everything's kosher, but the fact that I could look in at nighttime and turn my head and see the sales floor and see some boxes of product, that constitutes as advertising. So I just thought that, where's the line? Where are they drawing it? And at the moment, the regulators are kind of interpreting the statute and shooting from the hip at the same time. And that's dangerous. Even with meeting with regulators, it's kind of cautious that you want to ask them a question, but then at the same time you don't, because they're just going to shoot from the hip, and now it's on record, and you're on notice.
You don't want to open Pandora's box.
Exactly. So to your point, Zach, when you say that Florida's under-regulated, I tend to agree, but it's also at the same time, if there's no clear, explicit ban on anything, it's, in my interpretation, it's a gray area. And as long as we don't do anything illegal or explicitly blatant, then it's an operational decision. And we just mitigate risk that way. There's no way you can eliminate the risk. Compliance is more so just the mitigation of that and doing it within the bounds of the law. So that kind of surprised me in the marketing aspect.
I would actually take it out of Florida for a good example in that aspect. Pennsylvania to me is one of those interesting states because, for those that deal with Florida and everyone thinks, oh, Florida's crazy. Pennsylvania's, the regulators in Pennsylvania have very broad authority to decide on the, at the moment what they can and can't do. We sit here and we talk about, well, there's no regulation that says you can't do X. The regulators in Pennsylvania literally decided a couple years ago that the operators there couldn't sponsor events like this. Like, there was a big festival and they sent out a massive memo to everybody saying, you are not, unless you are approved, it is an advertising, and therefore you are not allowed to sponsor, have a booth, or do anything at an event like this, or any other kind of cannabis event, whether it's a hemp fest or 420 whatever, or an educational event. Every advertisement that you did, or any kind of publication that saw your name and your logo, had to be approved. To me, that's a little backwards, and if you're trying to promote and advance the growth of an industry, why would you do that? You know, it's when states think too hard, they overthink about how to do something. You know, sometimes it's, you know, more regulation doesn't necessarily mean stupid regulations, right? So you don't need to tell someone, well, okay, if you're a parent, you're walking in with your child or your spouse, the spouse is not allowed in the store. Well, no, the spouse is allowed in the waiting room. You don't want to put them on the floor, okay, that's fine. There are states that have that. You know, Florida, I think one of the most unnecessary things in Florida are the two things that I've seen. The 12-month GMP requirement in Florida, to me, is backwards and unnecessary. Anyone who wants to be a player in this industry is going to get GMP certified. But to mandate 12 months, I don't know what it was, you know, that to me, I don't get it. And then in Florida, I think the patient rooms, you know, in Florida, in each dispensary, you have to have a separate, and it's not just a separate area, you have to have a separate room that is not seen from anyone else in the store for patients to go. I understand the reasoning. If the patient wants to go call their doctor, you know, if they want to have a moment to learn about the product without anyone else around, that's fine. But to me, that's a business decision that the MMTC should be allowed to do. I don't know many other MMTCs that will tell you that room gets utilized. I mean, does yours?
I haven't seen anyone.
Yeah, so.
I think out of state, a good example would be Nevada. Department of Health originally oversaw the program, which is now under the Department of Taxation. So one of the things that survived was mandatory bathroom log cleanings. So if you didn't log the cleaning of your bathrooms daily and you had an inspection, that was a demerit that would be sent via the Department of Tax or Health at the time as a notice to correct. In Florida, I think this new hemp thing's a problem. I don't know how they can insist you can't sell a product that's not regulated by them.
Working on it.
So I'll leave that in Zach's hands, hopefully.
Now, we talked a little bit about employees and training. How do you keep your employees abreast of what's going on in the industry and making sure that they're compliant when there are a lot of hourly employees, there's a lot of turnover, there's a lot of people who are trying to be employees that might not necessarily be interested in working as employees, but might want to be more just affiliated with the industry and things of that nature? Do you have any insight as to what is an effective way to motivate and keep good employees and keep them compliant and trained?
Yeah, so when you're dealing with, you know, these license holders, you have, you know, hundreds and hundreds and hundreds of employees. So the challenge is making sure everyone is on the same page, everyone gets the same message, so you can check that box on your onboarding. And that's when it's crucial to kind of understand and get a good HR person, and even more so, a good training manager position within your company, so they can craft that onboarding process. You know, when I first started in December, GrowHealthy had 0 stores, and you know, it was only about less than 50 employees. Now we're over 400 employees. So with that scale, videos, that's kind of what I leaned on, is training videos and updating that. There's a lot of great programs out there where you can just run through a PowerPoint really quickly. Also, you know, video record yourself and just have at it. And that can be updated in segments as well. So as an additional policy comes into place, additional regulations come into place, I can update that fairly quickly and efficiently, rather than running through each new process of batch of people and running through my entire compliance training component. And also, not only the compliance training, you have, say, forklift training, OSHA training, EHS training, security training, active shooter training, bomb threat training. All these type of trainings, HIPAA training, you're gonna have contracting entities that specialize in that type of stuff. So, you know, bringing that contractor on board and creating an online module is really a great way to do it in terms of just, saving your capex and for efficiency's sake. So that's kind of what I see is I guess, the easiest way to kind of train large numbers of people and make sure everyone's on the same page.
I'd agree with that. I think it's, continuing education as well as regulations continue to change, making sure employees have access to information that's pertinent when those changes go into effect. I think, with the scale of the business, especially here in Florida, being vertical, it's also understanding the context of the regulation. I mean, people have specified roles, but understanding where their piece fits into the puzzle in relationship with other regulations around the product that we're selling helps really create a really more unified approach to regulation.
Okay, and I think we'll do one more question before we take a question from the audience. And the last question would be, can you provide some insight about what the timeline would be to bring a new product to market in terms of having the idea, being able to present it to the regulators, and then actually being able to put it on the shelf? Can you give some kind of insight as to what that sort of looks like for the average product? Some people would hope that these things come out immediately, but we all know that that's not typically the case.
Yeah. So, for us, right? So we were number 7. We weren't part of the original 5. We got our license through settlement. We had an initial application that we put forth with the department, and in that application, it set forth a few SKUs and products that we wanted to sell. Of course, as time went on, it came from a low THC state only to medical marijuana, what we have now. So, of course, for example, the flower aspect, or even bud baskets, or vape pens, or disposables, that all necessitates a lengthy variance process. And within that variance process, for each product, you have to go down to the minutia of the details. And rightfully so. We're talking about ASTM certification for the packaging to ensure that it's CR compliant, child resistant. We're getting down to the production standard operating procedures on how that product is made, how it's transported, and how it's packaged. We're getting into the machinery of what's used to create that product, the spec sheet of that machinery, the user manual for that machinery, even down to the dye lines, the labels, everything that you would imagine to put together that product has to be submitted via variance to the Department of Health. And it's very regulated in that sense. We haven't had many other states emulate Florida's model of so much initial groundwork to get a product release. That's why you're seeing a lot of time from conception to actual release because of this red tape component. But at the same token, it does keep your ducks in a row to ensure that you have everything and your boxes are checked. So that, I guess, more or less is the variance process.
Yeah, I would say what a lot of operators don't think or realize everything that necessarily is required. They want to get a product out. And it's because of the larger scope of things like, okay, law enforcement needs to know about new products. They need to have records of the labels and what the product is going to look like so they can protect against fraudulent, or unapproved sales, things like that. What I've told a lot of people is, in a space like this, and not just in Florida, when you typically have, we'll say, over-regulated products, you inevitably, especially in the medical states, you inevitably have under-resourced regulators. And what that I mean is not enough money and not enough regulators and not enough resources on the regulator side to do the job they need. They don't have enough people, right? So inevitably the delay, and Adam can completely attest to this because we're doing this for Green Growth Brands right now as well as other MMTCs. The delay inevitably is just that the regulators in Tallahassee don't have the resources to evaluate all at once. You have 22 companies all trying to get their next 100,000 square feet open, get their next product to shelf. The problem you run into then inevitably is that, well, time is money. It takes however many days to print packaging, right? Well, if you're a $500 million, billion-dollar publicly traded company, you know, that works on quarterly, biannual, annual budgets, and you are trying to roll out a new product, you know what, it's going to screw up your next quarterly MD&A. It's going to screw up your next quarterly financial if you're set back because you couldn't get the regulators to approve a new cultivation site. I think that's the biggest delay, and it's not just Florida, it's everywhere. I mean, I come back to Pennsylvania. In Pennsylvania, when the program first started, there was 3 people that were charged with inspecting every location within 6 months. It's impossible, you know. I think in a lot of states, Nevada is another one that does it a little bit faster though, right? I mean, you were just saying, like in Nevada, it's like 30 days, they'll turn around and approval.
Yeah, but every time you change a color on a label, you gotta get it approved.
So.
And I think I want to touch on inadequately funded program. You know, I think what's unique here about Florida is the program is pretty robust at this point. There's just no tax dollars associated with the program. So you have in other states these strong programs, but sales of medical marijuana and eventually recreational marijuana fund these programs fully and then some. There's no mechanism here to fund the program in Florida. So as you go from 50,000 patients to nearly 300,000 patients in 14, 15 months, and you go from 30 stores open in the state to a few hundred stores open in the state in that same time frame, or pathway to that in the same time frame, you need to obviously increase the size of the budget. You need more regulators, you need more inspectors, you need more staff just to handle general paperwork. And it's ultimately created a bottleneck we're going to be dependent on the legislature, I think, to increase the budget. And here that could be difficult.
Are there any questions from the audience?
In respects to the confusion between the rules and the regulations, when you have inspectors that come in and make decisions on the fly, how do you handle a situation where you may get conflicting decisions from inspectors? One inspector says either at one location versus another location this is fine, whereas another inspector says it's not. How do you deal with something like that?
I mean, we had an issue where during an inspection, something was noted as okay, and then in a secondary follow-up letter, we were told to correct it or provide proof of correction. Ultimately, you do what the letter tells you to do because you don't have much of a choice. That's just where kind of the buck stops.
Yeah, I mean, I had to do a number of either grow site inspections or retail inspections. It happens, one, you do it a few times, you build a rapport with the inspectors, so you kind of know what they're going to ask, and you show them what they know they're going to ask. That being said, you paper the hell out of it. I mean, if you saw a conflicting report, you paper it, because this is, my attitude before I came to Akerman. I'm gonna, build up his ego a little bit. I would tell people the last thing I want is Ari Gersten or John Robbins suing me. I really would tell people that, right? The last thing I would want if I'm the Department of Health is a motivated lawyer suing them because they can't get their act straight. And so my take on it was, I'm going to paper the hell out of it. If an inspector told me something different than he did on the last one, I want clarity on it, and I'm going to put it in an email or a letter, and I want the department to respond. Because God forbid it gets to the point where I have to now advise my client, you know what, we should threaten suit because they're not being clear on this. As a lawyer who previously litigated, now works with litigators who do this professionally, the first thing they're going to say is, show me every record you've got. Show me what proves your point, right? So when you get those conflicting reports, I would just make sure you've got your records lined up clean. And then to Adam's point, yeah, you do what you have to do to get it open.
Right, that's obvious.
Hello, Alex Bonnick with Green Cloud Security. We've heard a lot of talk about security. I'm specifically talking about cybersecurity. Now that we have SAFE where the banks are able to process payments. My question to you is, where do you see cybersecurity as far as you managing the daily risk of the attacks, or perhaps being part of the compliance, where you will have to produce some kind of cybersecurity assessment? Just want to know, what do you do on a daily basis to mitigate risk of the attack, as well as, being compliant?
It's all necessary at this point. Most states, well, beyond the financial aspect that you talked about, in most of these states, especially for medical, you're dealing with patients, patient data access information. So companies that are operating in other states where it clearly says you must comply with HIPAA, right? So that's the first thing. Companies have to approach this as, yeah, this is part of my operational cost. This is part of my operational need. Just as grow lights are, having, whatever your cybersecurity plan is in place, down to secure servers, whether or not, if you're going to use AWS, or you're going to use Microsoft, or, if you're going to use a SharePoint line, making sure that it's HIPAA compliant. On the security aspect, the financial, most of these companies are using third-party vendors, whether it's for merchant services or direct bill pay or ACH or whatever it is. I used to insist within the contracts that there was either some indemnification or protection that third-party vendor, the security provider, was insuring for it. That's from a company's perspective. From your perspective, I'm making sure you've got really good insurance and that you can stand behind your product. That's like the old adage of, would you use your own product or not? And if you can't answer that question, then you're not doing it right.
And to further Zach's point, under high tech and HIPAA, I would consider license holders as a covered entity. And to that fact, any contractor who's dealing with my PHI, my patient health information, they're executing a BAA before we do any scope of work. So the business associate agreement. So that just ensures that whatever the contractor is doing, they're compliant on their servers, and they're HIPAA compliant to ensure that they have proper protocols necessary to handle my PHI.
From an operator's perspective, I'd also say you need to make sure that your third-party vendors understand the ramifications if their stuff fails, right? It sounds obvious, but if you're hiring a cybersecurity vendor, they need to understand what happens if you get popped in one state compared to the next. Is it a financial fine? Is it a criminal penalty? That helps, I think, along the way for clarity. So.
I have two questions. One, as a compliance manager, I can talk about it, it's fine. As a compliance manager or officer, do you ever feel in any way personally liable if you made a call regarding compliance that was in the end held by a court to be against the law? Are there any compliance officers who are being prosecuted for making bad calls anywhere in Florida or other states?
Yeah, I'm not sure as to the prosecution aspect of it, but personally, yeah, I do feel liable to that extent, because the way I look at my job is that it's somewhat of insurance, right? It's compliance. What's on the line is not only my job, but also millions and millions and millions of dollars, just the value of the license in and of itself, revocation for that license, and also, our shareholders that we have to account to, because we are publicly traded. So yeah, I definitely sense a personal, connection with every decision that I make. And before I issue a decision, I always like to kind of vet it out, whether that be with my internal compliance specialist, or even maybe calling Zach, just to talk it through. So yeah, definitely have to run it through its course of due diligence, because again, this is a new industry, and no one knows it all.
But nobody's been prosecuted yet for making
No,
bad calls?
Without turning this into a law school class, there's certain legal steps in place that if an employee is doing something in the scope of his job, or if an officer is doing something that wasn't malicious. But I mean, to your point, if someone who's a compliance director or compliance manager just makes a bad call, right? In that sense of like says, okay, company X, you can do this, right? And
Operates within.
right, you know, and they had, you know, within my belief, blah, 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 right? And then the department regulator comes in and says, no, you can't do that. Not that I know if there's any criminal negligence, you know, unless it was deliberate, but.
That's very different than like, you know, shipping oil from one of your operations in Minnesota to New York where you might need some oil for your operations there. That would be something where a compliance officer would likely face prosecution if they endorsed a proposal such as that.
Right,
A
right.
good faith mistake, subject to interpretation, unlikely.
Okay, and my other question was, if you were talking about that there's no mechanism in place right now for funding these regulators, I don't know if there's a preference on the part of operators or license holders for some mechanism to provide funding for additional clarity, or if you prefer to sort of have a lack of clarity.
So Ari and I actually had this conversation yesterday. Medicine in the state of Florida is not taxed. And that's really why there's no tax on medical marijuana. I think it's the only program in the country that I know of that has no tax. Somewhere as low as 3%. But you know, on a program that's going to do a few $100 million in revenue this year and probably more than double next year, it's substantial money to help fund a program that relies on a very split legislative body in the state of Florida to fund it. Ultimately, they're at the mercy of a legislature that's really been at odds with them from the beginning. And it creates, you know, definitely a backlog for us as operators.
Yeah, I would actually take it a step further and say there are 22 operators in Florida right now. I would put money on the fact that if you were to poll all 22 and ask them, are you willing to allow your revenue to be taxed? If it allows for more clarified, you know, better funding of the regulators, I would think most of them would say yes, to a certain extent, right? But if it helps speed up the program and allow them to operate.
Yeah, actually, to Zach's point, given the unique nature of the licenses here as being vertical entirely, there's no wholesale tax, there's no transfer taxes between different steps of the process. In Nevada, you know, there was the cultivators and processors paid a tax on top of the tax that was charged to the patients of the medical program. I can't answer that it'd be okay for us paying an exclusive tax, but I definitely think there needs to be a solution to the problem.
Yeah, and to Adam's point even further, you know, when you look at states that are horizontal, there's the whole other fact of you now have more entities paying state income tax, right? When you've got to spend, you've got retailers, you've got wholesalers, production, growers, security, et cetera, et cetera, et cetera. So, you know, that's the give and the take. Any other?
Do we have any other questions? Otherwise, I think our time is up. No? No? No more? Mr. Stein?
We have cannabis in Florida because they wanted a medicinal program. The only reason we got this thing going is because Charlotte Whitney was sick. They saw some compassion there. They said, yeah, we'll do it as long as it's a strictly medicinal program. Now, we have the tax aspect of that we don't tax medicine, so therefore it's free. There's no excise taxes and various steps and that sort. But beyond that, once you go into the dispensaries and you ask them a medical question, the guy behind the counter, oftentimes what you get is a, I would say, more recreational answer. I'll ask somebody if they have, they know what they have for arthritis and lower back, you know, tell me what kind of buzz I can get from the various products they have, which is a recreational answer as opposed to a medical answer. And so I did some investigation, and one of the people at the counter said, well, we're not allowed to make health claims. So if this is a medicinal program, why are they not allowed to treat this like you're going to a pharmacist and talking to your pharmacist about medicine that you're supposed to be taking? And how can we, and at that point in time, is there going to be any really need for transformation to a recreational program? It would essentially be beyond the doctor's offices. We already have essentially a recreational program.
I think patient education is paramount to the program success. I know in Nevada we had which wasn't required by regulation as it is here, we had a doctor available to patients via email and phone call at all times, as well as weekly, which are now monthly due to the state of the program, but weekly free informational seminars for patients to come at an adjacent space next to our dispensary. To your point, yeah, a lot of the people that are hired in dispensaries are not trained to be pharmacists, but at the same time, they're also not pharmacists. So it's about educating your staff on the products. It's also about providing adequate education, materials, and patient information. But it's something we need to work on as an MTCs. As the program grows, it's also about making sure that the primary purpose of the program remains true to its core.
Yeah, so, to add on to that point, we're dealing with hundreds and hundreds of hourly employees. And it is essentially some are college kids, some are older in their 40s, and it's incumbent on us, and this is what we do. We make it sure that they understand that they need to provide the education. For the most part, when a patient goes to the physician doesn't know anything because they don't teach that in med school. So they still have questions, and they're relying on our staff to answer those questions. So in part of training, not only do we go through the products, but we also go through the ailments associated with what those products could be intended to help with. So we go into the pharmacology, we go into the pharmacokinetics of it, and we go into the endocannabinoid system and actually teach that science via literature and training videos to our staff and quizzes to ensure that whatever they're getting trained on is absorbed. So we try to do our due diligence and our part to actually impart that education on our hourly staff to ensure that when they do get fielded questions, they at least know how to answer it coherently to some extent.
I think Vijay actually touched on a really important aspect there, right? When you go to your doctor and you have an issue, the doctor says, I'm going to prescribe X, right? And the doctor says, X is used for these things, and this is what I think it may do to help you, and this is why you're going to the pharmacy to get X, right? We don't have that in today's medical field, right? There is not enough doctor education. So, when you walk into a medical marijuana dispensary, if you want to focus truly on the pharmaceutical aspect of it, right, they should be walking in knowing exactly what they're getting because their doctor educated them on what they should be looking for, right? So I would say, yes, patient education is important, but there's only so much that the retailers can do where the doctors, and there are some great ones, but there's not enough. Bless you.
Yeah, I think it's also limited research. Cannabis is an important science at the moment. It's a lot of trial and error. Varies from strain to strain, from delivery method to delivery method. Ultimately, given the restrictions around the plant over the last century in America, there's been limited research. And I think over the next decade or so, mostly out of Europe and Israel, but Canada and eventually America, you'll see groundbreaking work that will allow for much more clarity in terms of what's recommended and to who and for what.
All right, I think that's going to wrap it up for us here. Thank you everyone for attending.